case, which is HI-SHEAR Technology versus United Space Alliance. You can begin when you're ready.
May it please the Court. My name is David Lerner from Litchfield and Christopher in Orlando, and I represent appellant HI-SHEAR Technology Corporation. With me here today is co-counsel Michael Kahn, and I'd like to reserve 3 minutes for rebuttal. In this case, HI-SHEAR sued USBI and the Space Alliance for misappropriation of trade secrets in separation bolts that HI-SHEAR made for use on the space shuttle. Also sued USBI for breach of limited use provisions and contract documents and subsequent contracts between HI-SHEAR and USBI to manufacture separation bolts for the space shuttle. And in addition, also sued USBI for fraud in the inducement with respect to a contract for yet another product HI-SHEAR was to make for the space shuttle, a product called reefing line cutters. The trial court below granted summary judgment in favor of USBI and the Space Alliance on all three of those claims, and HI-SHEAR contends that summary judgment should be reversed because there are genuine issues of material fact on each of those claims. And in the case of the fraud and the inducement claim, the trial court also misapplied controlling law. With respect to HI-SHEAR's claims for misappropriation of trade secrets in count 8 of its complaint, the issue really turns on the nature and effect of the terms of a direct contract between NASA and HI-SHEAR back in the early or the mid-1970s, and also turns on a second issue, which is the nature and effect of the terms of HI-SHEAR's contracts, subsequent contracts with USBI to manufacture separation bolts. And I'd like to first turn to the argument with respect to the NASA contract. With respect to the direct contract between HI-SHEAR and NASA, the issue below really turns on whether the contract was a firm fixed price contract or a cost plus contract.
What is the evidence that you believe would support your argument that this was a fixed fee contract?
The evidence comes from Hans Nine, who...
Okay, assume that I have read that and believe that that evidence can only be read one way, and that is that Mr. Nine very strongly believed that this was a cost plus contract. I don't think that's ambiguous. As I've read it, I don't think that's a question. I think he saw this as a cost. He said, you know, there's no way that your client would have ever entered anything but a cost plus contract. I saw the contract. I read the contract. I remembered it was a cost plus contract. And then somebody asked the question, well, are you sure it wasn't a fixed fee? And when he heard fixed fee, he said, no, 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 and then went back to say it was clearly a cost plus contract. So take that away. Is there any other evidence that you think supports your argument that this was anything other than a cost plus contract?
There is, but with all due respect, I disagree with you.
Okay.
Hans Nine also said that, no, in fact, I remember HI-SHEAR entered into a fixed price or submitted a fixed price proposal, and then he testified that it was HI-SHEAR's proposal that was the best one that he argued in favor of and that ultimately was accepted. I think his testimony is internally inconsistent, which creates a genuine issue of fact on the very key material issue, and I think that's sufficient to have resulted in denial of summary judgment. To go on to your question, next question though, or your point, it brings me to my next point, which is the NASA contract is missing. It is not in this record. And under the evidence rules, the parties are entitled to prove up the contents of that contract by looking at other evidence. And the other evidence in this case is based on the subsequent conduct of the parties here. In other words,
NASA or the other side presented Nine's testimony, which we disagree about what it means, other NASA employees who all said that it was a cost plus contract, and 2 HI-SHEAR employees who believed that it was a cost plus contract. There was no direct evidence that you presented unless you read Nine's the way you read it, that this contract was anything but a cost-plus contract, correct?
Well,
And all the direct evidence presented was from both HI-SHEAR's employees from the 70s and NASA employees from the 70s, was that this was a cost-plus contract.
well, I'm sorry.
Go ahead, with the caveat that you think that Nine's
Right, but there's another caveat too, Your Honor, and that is that there was also testimony in the record that the other witnesses who formerly worked at NASA said, oh, I don't even remember looking at the contract. You know, it wasn't my bailiwick to look at the contract. I didn't see the contract. I can't find the contract. Oh, yes, but I remember it was cost plus. So I think the jury was entitled to hear their cost plus testimony in the context of their purported lack of memory and lack of foundation with respect to having reviewed it or been involved with it, with respect to the HI-SHEAR employees.
But maybe that's true if there was evidence on the other side saying it was a fixed fee contract, but if all the evidence, however weak or strong it is that it's a cost-plus contract, how does that create an issue of fact to go to a jury?
Well, again,
Just because, you know, some of those witnesses say, well, I didn't see the contract, that might impeach their testimony, but if all the witnesses say it was a cost-plus contract, how's their jury issue?
I don't think all the witnesses did, and in particular, I don't think the HI-SHEAR witnesses did, Your Honor. There's also affidavit testimony in the record that was not subject of any sort of a motion to strike or any sort of a challenge, where the HI-SHEAR witnesses testified that, in fact, USBI and the Space Alliance on summary judgment had mischaracterized their testimony.
You're talking about your current employees who have no knowledge of the contract.
No, sir. I'm talking about the Mr. Berg and Mr. Williams, who were working with HI-SHEAR back in the 70s. Their testimony in opposition to summary judgment was that, again, it wasn't our position to review the contracts. We weren't involved in the contracts. Therefore, we don't know what the payment terms were. All they testified to in their direct examination in deposition was that, to the extent that, I assume we're getting paid. But again, the point is, getting paid is different than getting paid under a cost-plus contract or a firm fixed-price contract. And it's important because if it's a firm fixed-price contract, then it means HI-SHEAR owns the technology. If it's a cost-plus contract, in this context, it still doesn't necessarily mean HI-SHEAR didn't own the technology or preserve the rights. And that gets back to the point that I was making before, which is when you look at the subsequent conduct of the parties, which you're entitled to do because the evidence rules say that when there's a missing document, you can prove up the writing any other way. And in fact, evidence rule 958 says that it's for the trier of fact to determine whether the other evidence of the contents of the writing really reflect the contents. And there's evidence in the record that the subsequent conduct of the parties is consistent with either a firm fixed-price contract in which HI-SHEAR owns the technology and the rights, or in the alternative, even if it was perhaps a cost-plus contract, that there was another contract provision that still protected HI-SHEAR's rights. And that testimony is through Don Reed, who was USBI's senior executive, who represented to HI-SHEAR's president, George Trahan, as late as 1999, that USBI always had and will hold HI-SHEAR's information received from HI-SHEAR proprietary and confidential. And there's further corroborating evidence in the form of a written memo from USBI's Charlie Couch, who was hired as a special project manager and facilitator. And in August of '99, he sends a memo to HI-SHEAR saying, look, we want to go...
Is there any evidence that Mr. Reed knew whether this technology was a protected trade secret or whether it was really NASA's to begin with?
There's no evidence.
I mean, because it's sort of different to me. If he was there in the 70s and knew who paid for the development of this technology, then if he in that context said, we're going to protect your trade secrets, it might be evidence of something. But if he has no knowledge of whether this technology belonged to NASA, completely was governmental technology, or whether it was a trade secret of HI-SHEAR, then to me I don't see how it has any evidentiary value, whether it tends to prove or disprove that basic fact if he, 20 years later comes back and said, we'll keep this confidential.
Well, I don't think there's evidence one way or the other on that point that's direct evidence. There's certainly no direct evidence that Don Reed was around back in the 70s, but the theory of USBI and Space Alliance was that NASA transferred these rights to USBI, and that's how it obtained these rights. Therefore, his statements and his testimony, as well as the memo from Charlie Couch in August of '99 saying that they will keep HI-SHEAR's information confidential and will not share it with competitors, is really tantamount to an admission that regardless of the basis, that is USBI's position as late as August of 1999. And all of that, Your Honor, is consistent with the underlying contracting regulations that suggest that a cost-plus type of contract is not appropriate for space exploration and development. And on top of all this, there is no evidence in the record. In other words, USBI's position and Space Alliance's position really turns on who paid and for what. And the for what is very important. And there's no evidence in this record that HI-SHEAR has any record of receiving any payments for NASA, much less the terms of the contract that show what payments might be for, an end product versus the design and the technology going along with it. And that really brings me to my next point, which is, as we discussed, summary judgment was also inappropriate because there are ambiguities and inconsistencies creating conflicts in the terms of the subsequent contracts between HI-SHEAR and USBI to manufacture separation bolts. So in addition to the genuine issues and the inferences coming from those, which HI-SHEAR should have had the benefit of on summary judgment with respect to the NASA contract, had the same problem and the same issues of fact with respect to the subsequent relationship between USBI and HI-SHEAR. What the court below did was focus only on isolated provisions of one aspect of the contract. But the contract said you apply Florida law when you construe them. And so when you do, you have to look at the various documents that comprise the entirety of the contracts. The various documents include the terms and conditions, the purchase orders, the statements of work, and the data rights clause, and any other documents that might be incorporated. And when you look at all of those together, the documents are internally inconsistent, and therefore they're ambiguous. And then when you look at the ambiguities against the other evidence, again, there are clear issues whether or not HI-SHEAR's rights were retained, and therefore summary judgment was inappropriate. The data rights clause, which is what one aspect that the trial court focused on, has a provision that says if documents are withheld from the government, documents containing trade secrets are withheld from delivery to the government. And on this record, there's clearly no evidence that while the contracts with USBI were in place, HI-SHEAR delivered or furnished any technical data packages for bolts to the government. In that case, the rights are protected. There's a subsequent provision in the data rights clause that deals with the contractor's allocation of rights, and it says that in the event that documents containing trade secrets are withheld from delivery to the government, then the contractor has the right to prevent anybody else from disseminating the documents, and that's what we have here. In other words, by virtue of the data rights clause itself, HI-SHEAR's rights were retained, contrary to the interpretation given by the trial court. In addition to that, the statement...
Let me ask you this. What trade secrets are you talking about now with respect to this contract? If the patent had expired on HI-SHEAR's original bolt, and if the trial court was right that this was a cost-plus contract and that the Christian doctrine applied and all the other findings, that all the development of what ultimately became the bolts on the shuttle was technology, data, and everything else owned by NASA because they paid for its development, the government owned it, then what trade secrets would you be talking about?
Well, there's under seal on this record, there's a list of 44 trade secrets that HI-SHEAR was claiming in the case, 37 of which relate to separation bolts. Of course, that's the ultimate fact issue in the case, but it would still relate to all of the 37 trade secrets because there's evidence in this record from HI-SHEAR's witness, Mr. Berg, that suggests that regardless of the patent did not disclose all of the elements and the details of all of these trade secrets, and therefore there is a fact question for the jury.
I thought counsel sort of conceded that during what started as a trial when he said, listen, given your ruling about the patent and the development of the bolts for the shuttle, there's really nothing left to try, so you should enter summary judgment because we can't prove any trade secrets, given those rulings.
Well,
I'm trying to, I still don't understand what trade secret you're talking about, if the trial judge was right in its interpretation of the original contract and what that means in terms of who paid for the development of the shuttle bowl.
yes, sir. It's still all of the trade secrets. There was no.
Then what was counsel talking about at trial when he conceded we don't need a trial because there's nothing left to protect?
Well, there's nothing left because the trial court's rulings, and again, the key is just as you said, it's based on the trial court's rulings. There was never any concession or argument by HI-SHEAR that the trial court was correct on its rulings.
Right, I agree.
Right. I mean, so that's not what we're talking about. But the trial court's rulings, the effect, and that's what we had to deal with at the time, was to put HI-SHEAR in a box. If you know, any trade secrets, and again, all 37, which is the ultimate fact here, all 37 were encompassed within all of these issues. If those were developed during the NASA contract, under the judge's prior ruling, HI-SHEAR had lost those. Under the judge's subsequent ruling, whatever may have been left, if it was either first developed during the USBI contracts or delivered to USBI, then in that case, HI-SHEAR had no trade secrets. So it doesn't matter which of the 37 we're talking about. Any and all of them were gone based on the trial judge's ruling. And certainly, HI-SHEAR had no obligation, did the professional thing by saying, look, based on your rulings, we have nowhere to go. We're certainly not going to put everybody through the burden of a trial when there's no possible way we can avoid that. And that brings me again back to the issues with respect to the USBI contracts. Again, the statements of work that are part of the contracts contain provisions that clearly make it so that documents furnished to USBI were for limited purposes only. There are terms and conditions for services that were incorporated in the contracts that also incorporate USBI's business ethics that consistently say we are clearly going to protect, and we have an obligation to protect, the proprietary rights of our contractors. So you put it all together, and all of those things are inconsistent with the trial court's rulings.
Let me ask you this before you're into your rebuttal time, and that is, with respect to the other issue, the reefing line cutters, I'm having a hard time understanding your fraud and inducement claim when there was a letter from Blair in November of 1997, a letter back in December of 1997, that clearly said you're not going to get everything that you would need just to build the print. You're not going to get that because we don't have all the specs and everything that you would need to build the print. There's going to be some design work. And then after that, you sign the purchase order contract with a merger clause saying that this is now the contract and all prior discussions are merged into this contract with an explanation of work that includes design and development. And since that occurred after your client was clearly put on notice that they weren't going to get all the documents, I'm having a hard time understanding how that could be a fraud in the inducement.
Let me help to clarify that for you, Your Honor, and thank you for that question. The December of 97 letter is just one piece of evidence. There's also other evidence in the record, including multiple memos from USBI where it still represents, even after that it was a build-to-print contract. There is an email from USBI's Larry Tanner in late 1998, well after the purchase order was definitized, that says, I thought this was a build-to-print contract. I disagree with you a little bit on the facts. The final purchase order that was definitized in end of 98 also said that no design and development is needed. That's what the statement of work said. And there's testimony from Mr. Silverman in the record that says, regardless of all this, I was being assured verbally continually through February of 98, through the purchase order being entered into, that this was build-to-print contract and I was going to get all of the designs. And therefore, what that means is, as this Court's LaPesca opinion says, you look at the timing of the misrepresentations. The misrepresentations began well before any contract was entered into. That's when HI-SHEAR was injured by relying on those, and the injury and the damage due to the fraud was based on entering into the contract in the first place based on those misrepresentations. And that
but if it was, say it was supposed to be a design to build contract, but your client, I mean, there clearly is written documents going to your client saying we don't have everything to give you because our other supplier won't release and let us give it to you. You entered the contract knowing that, it appears to me, so why isn't, even if it's supposed to be a design-to-build contract, why isn't that just normal contract damages? They didn't give us everything they were supposed to under the contract, so we're entitled to contractual damages. Why? I just still don't see that as a separate, really a separate and distinct issue under the facts as I understand it.
As this Court's LaPesca opinion says, it's just the difference between fraud in the inducement and fraud in the performance.
Right.
It's the timing of the misrepresentations. Here, the timing was well before the contract was entered into, and LaPesca even says the fact that misrepresentations may be incorporated into the contract does not vitiate the fraud, and LaPesca further says that the measure of damages for fraud and inducement and breach of contract may be the same is irrelevant in this analysis. And therefore, in closing, let me say that for all the reasons that we've discussed, the issues of fact on the NASA contract, the issues of fact on the USBI contracts, and the issues of fact in misapplication of law on the fraud and the inducement, the summary judgment should be reversed. Thank you.
Well, you've succeeded in exhausting your time, but I'll give you a minute for rebuttal if you feel you need it.
Thank you, Your Honor.
Good morning. My name is Michael Busey. I represent USBI. Since there are two appellees, we'll be splitting the issues so that hopefully we don't duplicate ourselves with the Court's permission. I'll talk a little bit about the fraud claim, and then we'll talk about the Court's July 2005 ruling at trial. Mr. Levin will talk about the NASA ruling or the NASA contracts and a few other alternative issues. Just a few things on the fraud claim. Your Honor asked about the December letter, and that is certainly an alternative basis to uphold the trial court's summary judgment. But the trial court's summary judgment was based on the fact that the damages claimed for fraud were simply not different than the damages claimed for breach of contract. They were not separate, as the LaPesca Court requires. And, in fact, they were based on a specific contractual term, a termination for convenience clause in the contract. And that is a specific contract-based remedy that you'll only find normally in government contracts. So when HI-SHEAR told us what its contract damages were, it pointed to the termination for convenience clause of the contract and said, this is how you do the calculation. When HI-SHEAR then told us what their fraud damages were, they said, essentially, ditto. You look at the termination for convenience clause of the contract. And so what that shows, and in following the LaPesca ruling, is there are no damages resulting from fraud that are separate from breach of contract. They are, in fact, based on the contract and its terms, and therefore the fraud claim was properly dismissed by the trial court. Now, moving to the trade secret claim, I'm going to talk first about the July rulings regarding contract construction. And these were the USBI HI-SHEAR contracts that postdated the NASA contracts. The trial court made some very simple and limited rulings at trial on the trade secret issue. The trial court simply looked at the data rights clauses that were incorporated into the USBI HI-SHEAR contracts, and also looked at some other ownership clauses that were incorporated into the USBI HI-SHEAR contracts, and determined, as it was required to do, whether those contracts were ambiguous, so that the court could determine whether parole evidence would be admitted. And the court construed those terms and found that they were not ambiguous. That's all the court did at trial. Now, looking at those two sets of clauses, the first were data rights clauses. And let's put aside for the moment the NASA contract and what that did and what that effect was. The data rights clauses were put into the USBI HI-SHEAR contracts to protect the government's rights. For example, in modifications that were done after the original NASA contract. And the data rights clauses have two important provisions which say that the government, NASA, gets unlimited rights in certain types of data. And unlimited rights means the right to do whatever the government wants with it. It's essentially HI-SHEAR giving the technology to the government and saying there are no obligations of confidentiality whatsoever on you. You can do whatever you want with the data. You can give it to anyone else. If the Internet existed at the time, they could have put it on the Internet. Unlimited rights is a broad grant of rights to the government. The data rights clauses that are in every one of the contracts say that the government has unlimited rights in data first produced under the contract. And again, the contract we're talking about is the USBI HI-SHEAR contract. And HI-SHEAR doesn't contest the trial court's determination that the government, therefore, got unlimited rights in data first produced under these contracts. There's a second set of clauses that HI-SHEAR has contested, and that is the clause that says that the government gets unlimited rights in, quote, all other data delivered under this contract unless provided otherwise for limited rights data or restricted computer software in accordance with paragraph G below. And I was reading from section B1.3 of the 1984 version of the data rights clause that is cited in our brief. Now, if you take the two parts of that, the first part says the government gets unlimited rights in all other data delivered under this contract. There's nothing in this provision that says the data has to be delivered to the government. It says under this contract, and there's no doubt that the contract that was incorporating this term was the USBI HI-SHEAR contract. The second part of the clause says, unless provided otherwise for limited rights data as set forth in paragraph G. And paragraph G was the withholding provision. And what paragraph G of the data rights clause says is, if a contractor like HI-SHEAR has data that it believes it has trade secrets in, then it has to withhold the data and not deliver it. And the trial court, when it interpreted this provision, interpreted it in exactly that way and did nothing more. So the plain and unambiguous terms of the data rights clauses showed that the government would have unlimited rights in all data first produced under the USBI HI-SHEAR contracts and in all data delivered under these contracts, even if delivered to USBI. There were a number of other ownership clauses that were in the USBI HI-SHEAR contracts. One ownership clause said USBI would have ownership of anything done under the USBI HI-SHEAR contracts. That was a 1995 clause. There were later clauses of similar effect, and all the trial court did was look at the plain meaning of those terms and construe them. At that point, HI-SHEAR requested that the trial court grant summary judgment during trial. HI-SHEAR did not argue, and could have argued to the jury if it had wanted to, that the contracts had thereafter been modified. HI-SHEAR did not make that argument. Now, that argument would not have had merit, we submit, but by failing to make it, HI-SHEAR has waived that argument. HI-SHEAR didn't make any of the other arguments that it's made in its brief about implied contractual relationships or the UCC. The only issue at trial was looking at the contract terms and construing them. And HI-SHEAR's decision at that point to not go before the jury waives any other arguments. Unless the court has any further questions on the FAR data rights clauses or the July ruling or on the fraud ruling, I'll hand it off to Ms. Levin.
Factually, was the technical data package submitted to HI-SHEAR under the USBI separation bulk contract the same information contained in the development test report submitted under the NASA contract?
I think factually the original data, the original technology that was developed for NASA was very similar to the technology that was then delivered throughout the 1980s and 1990s to USBI. There were some modifications, there were some small modifications as the years went on, but it was very similar. It had the same types of drawings with slight modifications. Thank you.
Good morning. Michael Levin of Baker & Hostetler, representing United Space Alliance. May it please the Court. Germaine to your last question. In the record, there is the affidavit and deposition and expert report of Donald Wenzel, who will say that the data that was first provided was substantially the same as the data that was provided to another supplier, McCormick Self, and with small modifications over time, the same data that would be provided throughout. As I address terminology, development test report is the test report that requires the I'm a little confused by the timing here, Your Honor. It says 1926.
Yeah, that's because I don't have an easy 10 minutes to give you, but so just ignore the one.
Yes, Your Honor. All right. Suddenly got confused. The development test report is the description of the arduous testing process, which we put those reports into our appendix. The arduous testing process that resulted in this new technology, space shuttle separation bolts being created, 5 different types of propellant being tried until they found a successful one, the use of the lead coupling ultimately after 57 tests. Relates to the development of the technology. Production data package is the set of drawings that is contractually required under the specifications in the original statement of work, first to be delivered to NASA, and then under subsequent contracts, such as the 1985 contracts with USBI, had to be delivered to USBI and then ultimately the United Space Alliance. In our brief, we present as an alternate reason, another reason why there is no trade secret, is under the 1985 contracts, there's a reference to a statement of work. Actually, if you look at Bates number, I believe it's 333 in the version of the 1985 contract that's in tab 16 of the appendix, you'll see that it's referenced at 8011, the statement of work is attached. And the purchase order says that the statement of work is part of the purchase order. And so a mistake that Judge Moxley made below is to consider the statement of work not part of the purchase order, but the plain language indicates that the statement of work is part of the purchase order. If you track through the statement of work, as we've done in our brief, you see that a requirement of HI-SHEAR under those contracts is to deliver a production data package in sufficient detail to enable manufacture and fabrication of the contract end item by a responsible company skilled in the manufacture of similar equipment. The reason being, they want to be able to have another company that could manufacture this product, as the original specification said, there's going to be a second source. Purchase order also said that title to those delivered drawings passes to USBI. So whether you're talking about the production data package or the development test reports, there was not reasonable efforts to keep it secret because it was required that they deliver it. And they did deliver it. And long before those conversations in 1999, which were referenced by counsel for HI-SHEAR, any possibility of maintaining a trade secret was long lost. HI-SHEAR never had a trade secret in this technology. Under the June order that was entered by Judge Moxley, wherein Judge Moxley found that there were no trade secrets either in the technology disclosed by the patent or in the technology disclosed in the development test reports. You are correct. We all read Professor Nine's or Mr. Nine's testimony.
I figured you would think that.
Pardon?
I thought you would think
yes,
that.
we concur on that. And I've read it several times at page 157 of his deposition, and I don't think it can be read another way. But that said, it's all the testimony is the same. Mr. Berg, Mr. Williams of HI-SHEAR both said the same. We have in the record at 19407 is the deposition of Mr. Cuthbert, who had worked at HI-SHEAR from 1967 to 1971, and he was involved in the development of the predecessor bolt that's used in the Alpha Centaur rocket, the 40,000-pound, much smaller. And he said a couple things that were germane to this trade secret issue. He said that he never had a confidentiality agreement with HI-SHEAR, never had a non-disclosure agreement, and all the knowledge he obtained at HI-SHEAR regarding bolts, he took over to a separate company, SOS, which was one of the 5 companies bidding for the space shuttle bolts that Mr. Nine's review board evaluated before giving the contract to HI-SHEAR. So all of his knowledge that he obtained at HI-SHEAR, said he was free to use. He would be breaching his duty to SOS if he didn't use it. Mr. Cuthbert also said that he was shocked to find out in this lawsuit that they used lead as the primary component in the coupling rather than rubber. So this was, at the time of the summary judgment, a fully developed, well-discovered record. And there was no evidence that anyone could find.
It's decorated my entire office, so I know that that's true.
We all have file space problems. But it is in this well-developed record, there is not a shred of evidence that at the time this technology was developed, it was intended to be a trade secret by HI-SHEAR. Instead, it was intended to be the property of the United States of America for a very unique product, the United States Space Shuttle. And though there it remains. It is not a trade secret. The summary judgment was appropriate. Unless the panel has any questions about any of the issues, thank you for your time.
Mr. Levin, you're in your old age, I've never known you to give back time.
Your Honor,
I'm shocked.
maturity comes later to some of us.
I just can't believe it. All right, thank you very much.
Thank you, Your Honor.
Appreciate it.
I'm not as old as Mr. Levin, so that must be why I took longer.
Well, you better hurry, because you're using that 1 minute really fast.
Yes, Your Honor. With respect to the fraud claims, again, USBI's argument misunderstands LaPesca. The damage or injury was entering into the contract based on the prior misrepresentations. With respect to the data rights issues, everything...
But the alleged misrepresentation is what the contract said, right?
Correct. And LaPesca says that that's okay. You can't vitiate the fraud by incorporating it. With respect to the data rights issue, the fundamental technology underlying the separation bolts used on the space shuttle was clearly developed by HI-SHEAR, clearly used by HI-SHEAR. The space shuttle bolts are based on that fundamental technology, and the ultimate fact issue is who paid for the subsequent modifications. Under trade secrets law, even if USBI or NASA paid for those, HI-SHEAR is still entitled to trade secrets protection. The difference really comes down to whether there was private expense or public expense for those changes, and that is the essence of the disputed fact issues in this case. And for all those reasons, summary judgment should be denied. Thank you.
Thank you, counsel. All right, 2 very well argued, interesting cases. So we're going to take